What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. It's a Monday. I want to start you off on the right foot, so let's get to it. I got 4 cases for you. First one is Knott versus Knott. It's out of the 6th DCA, and that's Knott with Knott. This one is quite a doozy. It has a lot of different issues. The trial court basically screwed up a lot of things, so it's kind of like a do-over. So the first thing the trial court did was it found that the husband's partition action couldn't go forward because the court lacked jurisdiction to consider the partition action because the husband failed to plead the party's respective ownership interests in the property. In the partition statute, it requires that someone plead the specific interests that each party has in the property. And so the court said, well, the appellate court said, well, the husband pled in the alternative that the parties either owned it as joint tenants with rights of survivorship or tenants by the entireties. And so basically by saying that, he actually did plead the ownership interests, I guess, because tenants by the entireties, each party would own a 100% of the property, and if it's joint tenants with rights of survivorship, each party would own an undivided 1/2 interest in the property. So I guess by doing that, he actually did plead the ownership interest and satisfied the statute for partition pleading. So that was one thing. So he's allowed to make a claim for partition. The second thing that the trial court did wrong was it valued his business as of the date of filing, which normally would be an okay thing to do, but there was evidence in the record that the business substantially decreased in value post-filing. And the business valuator, I guess, valued the business using the net asset approach, assets minus liabilities. And so the value of the business bank account really decreased. It went from like $300,000 down to about $70,000, and there was no evidence of misconduct with regard to the decrease in value. And instead, there was evidence that the business was just declining. So the trial court erred by not considering the only bank statement, the most recent bank statement in evidence, which showed that it actually only had a $70,000 in its bank account. Something to consider when you have a case where you're valuing marital businesses. Similarly, trial court erred by valuing the husband's bank account as of the date of filing, essentially, even though it substantially decreased in value. And the reason the trial court did that was the husband essentially really had no excuse for why the bank account went down so much. Like before, he used to always withdraw like only around $2,000, and then now this bank account went down by $100,000 in the last year or so post-filing. The husband really had no excuse for why that happened, and so the trial court said, well, you have no excuse, so I'm going to say that that's dissipation. And the appellate court reversed and said, no, his failure to be able to recall what he did with the money, that doesn't count as intentional dissipation or misconduct. So the court was not allowed to do that and had to value it with its lower value. The other thing that the trial court did wrong was it found that assets acquired post-petition but with marital funds were marital assets. And the the appellate court said no. Cutoff date is the date of filing. So identification of marital assets, these are not marital assets because they were acquired post-filing. Even if they were acquired with marital funds, cutoff date, date of filing, acquired post-filing, not a marital asset. The final thing that the court did wrong was it failed to consider the former husband's decrease in income in the years getting closer to the date of filing and after that. Apparently, the trial court used a year prior to the date of filing where the business was doing much better, but there was evidence that the business was going down in value, and therefore the husband's ownership interests and his share of the profits were going down in value. So the court erred by using the 2019 value of his income when there was evidence that it was declining over the more recent years. Interesting case, multiple issues, so one to consider when you're looking at issues like that. Next case is Radko versus LeVi. This is out of the 4th DCA. This was a pickup order. And so this has to do with petitions to modify versus motions to modify. So apparently this father filed some sort of motion to modify time sharing, child custody, and parental responsibility. Essentially, the father was saying that the mother was failing to abide by court orders on time sharing, failing to abide by court orders requiring her to take the child to the hospital because the child was threatening to harm herself, And so he was saying, look, we got to do something here. Trial court agreed with the father and said, okay, I'm going to give custody to you, essentially, all the time sharing, transfer the child to you. I'm going to enter a pickup order and bring the child to in your possession. And so the appellate court reversed because they said, look, you're really trying to modify child custody, modify time sharing, modify parental responsibility. That needs to be done through a supplemental petition. You cannot do that through a motion. And apparently the court found that this wasn't a situation where there was an emergency, where you could file some sort of temporary emergency motion to modify just on a temporary basis while a petition is pending. So if I were the lawyer in this case, I would file a petition to modify, even if it's basic. You can always amend, and then also an emergency motion to modify on a temporary basis. So that's definitely something to look at if you have a case like that. Next case is Johnson versus Johnson. This is out of the 4th DCA again. This is one where the court, on a temporary basis during the divorce proceedings, granted the husband ultimate decision-making authority on all issues affecting the child's welfare, while at the same time ordering shared parental responsibility. And the court said, no, you can't do that, because that's basically doing sole parental responsibility, right? It's not like the court said, okay, you're going to get ultimate decision-making authority on specific issues as permitted under 6113. It sort of just gave blanket shared parental responsibility, but ultimate decision-making authority on all issues affecting the child's welfare. Can't do that. So that was reversed. Got to specify which areas. Last case is out of the 4th DCA. It's Schulmann versus Schulmann. This was a DV case, and this is one where I like to do this in that the lawyer for the husband. This is a petition for domestic violence. The allegations are kind of interesting. It's hard to say. Basically, it had to do with threatened battery and actual battery involving the husband grabbing the wife essentially in her private areas, and so the husband's lawyer moved for an involuntary dismissal at the end of the wife's presentation. But the problem was, when you do a motion for an involuntary dismissal, when you're doing that, during the hearing, the court still has to treat it like as if the mom or the wife, they have to take all of her allegations as true. And so what the court did here was it was clear that the court sort of weighed the evidence and didn't take all the allegations as true and then in the light most favorable to the non-moving party. It wasn't like that. So, and also it was kind of strange because they took evidence out of turn. So they used some of the husband's witnesses during the wife's presentation because of scheduling issues. And it seemed like the trial court actually considered the testimony of the husband's witnesses, which they can't do that on a motion for involuntary dismissal. So I like the idea of using an involuntary dismissal motion, but you got to make sure you're limiting that solely to the evidence that was put on by the non-moving party, and say, even if you believe everything they said, Judge, they still can't win. And so trial court really didn't get that right, so they got reversed. All right, guys, that's it for this week. Look forward to seeing you guys next week. Take care.